Good morning. Welcome to Davis Malm for our annual Spring Employment Law Seminar. I think by our count, this is our 7th annual event. So on behalf of myself, Tamsin Kaplan, Larry Casey, Robert Kaitz, and Dave Rogers will be joining us. Welcome. We're going to get this, we do have a jam-packed agenda, so we are going to get started.
So I get to talk to you about the new change to the Mass Equal Pay Act, which I'm sure everybody's here for. I don't think you care about anything else other than this, I'm sure. So basically, we did have a Mass Equal Pay Act. It has been revised. It's now more comprehensive. I'm going to give you a quick overview, and then I'll give you some of the detail. So it is effective July 1, 2018. So it's coming. There are some steps you can take to put yourself in a better position from an employer's standpoint. Under the statute, which we'll talk about in a second, it applies to all employers in Massachusetts. It even applies to employers who are outside Mass if they have employees whose primary place of work is in Massachusetts. So for some of you multi-state employers, you need to be cognizant of this act. It applies to virtually all employees. It would not apply to employees of a charitable association. So if you fit that definition, then your employees are not covered. So generally what the act does is it prohibits discrimination on the basis of gender. The statute clarifies what is discriminatory pay practices and imposes some new rules. It defines what comparable work is. Prior to that, we had case law. This is much more detailed as to what it is. The prior act only allowed seniority as a basis for varying compensation. This now gives you some other variations that you can use to differentiate on compensation, but they're very narrow, they're limited, and they're exclusive. And we're going to go over them in a second. You can no longer, under this act, ask an employee about their pay history. It is unlawful to prohibit employees from discussing their wages or talking about others' wages unless you're in certain types of positions, which I'll get into in a minute. And it provides for an affirmative defense for employers. So there are steps you can take to get that affirmative defense. There has been some guidance issued by the Attorney General's office. They're not regulations, it's guidance. They tend to be given deference by the courts. And those are worth looking at, gives you more detail on the act and some of the terms within the act. So the basic prohibition in the act. So let's get into a little bit of detail. So what it does is it prevents an employee from discriminating on the basis of gender for the payment of wages. And you can't pay any person that you have as an employee wages that are less than the rates you pay to other employees who do comparable work. Comparable work is a key term. It describes what it is, and we're going to go over that in a second. The other key word is wages. What are wages? Wages are any remuneration for employment. So we're talking salary, bonus, benefits, stock options, stock grants. All of that is part of the compensation. It all has to be done so it's equal. There's no differentiation on the basis of gender, so long as they're doing comparable work. What's comparable work? The current statute did not define it. As I mentioned, it was all case law. This new statute, which is effective again July 1, does define it. And what it does is it says that comparable work is work that requires substantially similar skill, effort, responsibility, and it's performed under similar working conditions. So let's just talk briefly about what each of those topics are. So let's start with skill. Skill is essentially, and this is in the guidance, experience, training, education, what's the ability required to perform the job, and it's measured in terms of performance requirements. And when you're looking at these factors, you got to look at the job as a whole. Effort is physical or mental exertion that's needed for the job. Responsibility include degree of discretion, degree of accountability, your duties, your actual duties, whether the number of people and who you supervise, and the degree that you supervise individuals, as well as the degree to which you are supervised. And then what's your decision-making capacity? Performed under similar working conditions. So you can account for different working conditions like travel, shift differentials, physical surroundings. It's an outside job versus inside. Are there hazards? Am I working with chemicals that are dangerous when I'm filling up packages, or I'm just filling something that's non-dangerous? So those things you can look at. And then the job title or description alone is not enough. So you can't say, oh, I gave them a different job title, they don't have to be paid the same. Under this statute, you're going to look at the job as a whole. The job title's not going to matter, the job description's not going to matter. However, if you have a job description or job title that is very accurate with what those duties, skill, and effort, responsibility is, well, that's great, because you can use that to do the comparison. But it's got to really work with what actually the job is. As we know, sometimes you do a job description, it gets stale, or the job isn't quite what it is, so you can modify those, which would help you in your analysis on comparability. Substantially similar is not defined in the Act, but what the guidance indicates is that the jobs are alike to a great or significant extent, but they don't necessarily have to be alike or identical in all respects. I'm not sure if that clarified anything for anybody, but if you study it and think about it, it does help a little bit. Pay differentials are okay in certain circumstances. And what the Act does is it limits to 6 basic instances where you can look to those, if those factors exist, or you have these things in place where you can differentiate on salary, even though it's between different genders. So one is a seniority system. So we pay the people who have been with the company longer. Again, when I'm talking about these systems, they really should be set up. They're pretty defined. You've got some objective standards. You don't want a lot of subjectivity, because then you're going to have people applying them unequally, and then before you know it, you could have a violation of the statute. So seniority system, merit system. You're indicating people are going to get paid more based on how they perform. And again, that means your evaluation systems are going to be important, and how you evaluate people. What are the criteria? You can use those and then start bumping people up. That's fine. But you got to make sure that those have some objectivity and concreteness to them in order to make them work. Next is a system measuring quantity or quality. So we're talking about employees who get paid on a commission basis. I've got a great number of sales, or I'm doing piecework, and I do a lot more pieces than the other person. Okay, you can differentiate and pay me more. Education and training, again, and geographic location. Those also can be, in experience, can all be differentiators, but they have to relate to the job. Just because Robert comes in, he's got an MBA, if it doesn't really matter for the job, it's not going to matter. It's not going to be a way to differentiate. If you had an accountant come in to be a bookkeeper, you could use that. It's because I know accounting, I'm going to be great at the bookkeeping, I know the systems, versus somebody who's never been a bookkeeper before, or has done it maybe for a smaller company. That could possibly constitute a way to differentiate. And then travel. Travel can be a differentiator. Again, it's got to be part of the job, part of the necessary requirements of the job in order to apply. One thought I want to put out there is at the bottom, there is also a federal Equal Pay Act. Our statute that is going to be effective July 1 is significantly different. And under the federal law, it allows any factor other than sex to be a differentiator. That's not going to apply in Massachusetts. And the comparable work under Massachusetts law is much broader than the equal work standard under the federal. So you might be in compliance with federal law, but not be in compliance with Massachusetts law. I would hedge to guess if you're in compliance with Mass law, you will be in compliance with federal law. Pay differentials also, they are not permissible between men and women for any other reason other than those 6 that I listed. It's an exclusive list. You can't come up with other ones and say, well, I'm differentiating on this basis and that should work. You've got to stick with the 6. Salary history is not a defense. You can't bring somebody in and say, well, they were earning this amount when they came, so I started them at the low end. That doesn't work. And there is no intent required to find a violation. You do not have to If somebody's suing you for a violation, they don't have to prove that you intended to discriminate. It's going to be very objective. If you look and there's a differentiation, the jobs are comparable, and there's differentiation in salary, there's a violation. So what do? You should be looking at your employees, looking at what your pay structure is, to see who do I have in jobs that are comparable, what jobs are comparable. You can start with your job descriptions, but you really got to dig in to make sure you know what the actual jobs entail. Then you got to look at what is the pay between different genders, and while this says men and women, there's different genders than men and women now. So you got to look at it from a gender perspective. You got to look to see, is there pay equality? If there isn't, are there any of those 6 factors that allow me to differentiate? And they exist, so I can rely on those. What happens if you violate? So if an employer is found liable, then you have to, you're liable for the unpaid wages. So that's be the difference. If, let's say it was $30,000 a year, it's $30,000. In addition to liquidated damages of the same amount, so now you're at $60,000, plus the reasonable attorney's fees that was expended by the employee to get you to recognize the differentiation and then come up with the money. You do not have to file with the MCAD or the Attorney General. Some of you may be aware of some of the discrimination laws, which under Chapter 151B had to file with the MCAD. Here you don't. You can file directly in court. You cannot use an agreement with the employee to work for less as a defense. That's not going to fly. And you can't, as I mentioned before, use previous compensation history as a defense. There's a 3-year statute of limitations, which means an employee can go back 3 years. So if you didn't pay me $30,000 a year, equivalent to somebody else, now we're talking $90,000 plus $90,000 plus attorney's fees. So it can get very expensive. It's certainly worth looking into this. There's a violation each time wages are paid. There's a violation each time a decision is made. If you hire somebody and you pay them unequal pay, there's a violation. When you give that person a paycheck, there's another violation. If you adopt a practice on here's how we're going to evaluate and your evaluations are differentiating based on gender, there's another violation. What else is unlawful under the Act which could make you liable for those, the violation of the statute, which would include the attorney's fees? Well, one is you cannot prohibit employees from discussing their wages, their own or those of others, with one, I'm going to say one exception, but with an exception. The exception is if you are an employee where you're in a position where your job responsibilities give you access to other employees' compensation information, well, then you can restrict that employee from sharing that. HR is the easy, typical example. Supervisor is an easy, typical example. But if, other than that, any employee can go discuss their salary with any other employee. Employees can talk about, I understand this person has their salary, you can't prohibit that. In addition, those exceptions, the HR folks and the supervisors, they can talk about their salary. They can't talk about other employees' salary because they can talk about theirs. So you should take a look at your company handbooks to make sure there's nothing in there that restricts employees from discussing those. Nothing on your forms, nothing on your offer letters, nothing in your contracts that do that. The other big thing, which a lot of people seem to be very concerned about, is you can't seek the compensation history from a prospective employee. You cannot ask them, what were you earning or what are you earning at your current place of employment? You can ask, what are your salary expectations? But I'm going to give you a big caveat there is you're getting close to the line. And if it's determined that that question was intended to elicit the employee's compensation history, well, then you're going to be in violation. I would submit I don't think you need to ask for employment compensation history. You can set a range of salary when you're putting out your positions, and then you put the person in the spot based on those 6 factors where they fit, or all our VPs are paid the same. And then we differentiate thereafter based on either the work they do or how well they've done it, i.e. their group is off the charts with sales or some other evaluated factor that's objective and you can back up a merit system. You can also not require a prospective employer compensation history to meet certain criteria. Again, stay away from compensation history is the simple thing. And you cannot retaliate against an employee who discusses or discloses their salary information or discusses other employees' salary information. And you cannot retaliate against an employee who opposes any violation of the statute or makes a complaint. So what can an employer do with regard to compensation? You can, from a prospective employee as far as prior history, you can confirm prior compensation if the employee voluntarily discloses it. Again, it's got to be voluntary. They blurt it out. You can then go confirm it. Or you can confirm it after you've made an offer with compensation in the offer, and it's been made to the prospect. So you can then check to confirm. So I don't know why you would want to do that, but you can do it. Maybe it's you want to check market and see am I paying market, but there's other ways to do that. Again, I'd recommend staying away from it. I don't see any real benefit to getting close to the line, particularly if you've taken all the key steps to get there and stay behind the line. Why would you want to cross it to have somebody contest when you actually asked for the compensation history relative to when you made the offer? And you can never use salary history, even after you confirm it, to justify any differential in paying employees of different genders different amounts that are obviously doing the comparable work. So the best thing that you can do as an employer is get this affirmative defense. The statute specifically allows an affirmative defense to these types of claims. In order to get it, what you need to undertake and complete is a self-evaluation of your pay practices. And it has to be done within the previous 3 years of a claim and before the claim is brought in court. So do it now. Start it now before the act is effective, and it'll cover you should any claims be brought going forward. You have to demonstrate that you not only completed and undertook that self-evaluation, you have to demonstrate that after the evaluation, if you determined there are certain discrepancies, you're making reasonable progress towards eliminating them. That reasonable progress is going to depend on the size of your business. If I'm a 6-person employed, I employ 6 people, it's not going to take long to do the evaluation and determine these people aren't paid, I do the raise. You can't drop somebody's salary to make it equal. You can only increase the people who are paid less. So for those of you who are thinking, hey, this is great, I save myself some money, it's got to go the other way. You can easily make that quick switch. Whereas if I've got thousands of employees, it may be tougher to do the evaluation and then to implement it over time. And that is going to be taken into consideration to determine whether you've made reasonable progress so that you qualify for the affirmative defense. And then last but not least, the evaluation has to be done in good faith. So you're taking the appropriate steps and you're really looking into the factors to determine it. And then it has to be an evaluation that's reasonable in detail and scope, again, in light of the size of the employer. You can get a partial defense if you cannot demonstrate that your evaluation was reasonable in detail and scope, and you will not be limited, you will not be liable for liquidated damages, again, so long as you're taking steps towards fixing what you found. The evidence of your self-evaluation cannot be used against you under certain circumstances. One, you have to go through those steps. And it's certain time limitations. So if you do the self-evaluation, nobody's going to come and say, look, here's the self-evaluation. These 6 people were found to, you've discriminated against them. They're not being paid equally, and one of them's my client. They're not going to be able to use that if the self-evaluation was completed, the violation occurred before the self-evaluation was completed, and you have completed the self-evaluation. Or the violation occurs within 6 months after you have completed the self-evaluation. Again, they can't use it against you. Or, and this is the best one, but it's the violation occurs within 2 years after the self-evaluation is completed, if you can show that you have developed and begun implementing in good faith a plan to address the discrepancies that were found. So that's going to give you the biggest protection. Do the audit, start the plan and start putting it in place to make progress against the discrepancies, and you're going to have 2 years of protection. So from an employer standpoint, that's the best thing to do. If you're representing employees, I would say forget everything I just told you. Don't do any of this. Anybody have a particular quick question?
Larry, is there, in the terms of equal pay, is there any guidance on, is that within a certain percentage of one person versus the other, a certain dollar amount? Does it have to be to the red cent equal pay?
Equal pay. Okay. Equal pay, and you consider everything. You don't just say, oh, the salaries are equal, but he's getting, stock grants every year worth, 0.1% the value of the company, and she's getting none, or she's getting 0.5, or vice versa. So it's you can't differentiate. So that's a differentiation. Now, if you can fit in one of the 6 factors, then it can be different, but it's got to be based on that. Yes?
In the case of a highly compensated salesperson, what would the discussion be around their compensation? Would there be any differences?
Well, is the salesperson based pay on commission?
Base salary plus commission in most cases.
Okay, so I would say, just top of the head without getting into the details, the base pay would be equivalent for both salespeople. But if you've got a high-performing salesperson who's hitting it out of the park and their commissions are, 100 grand a year, and the other person is getting less, you could account for that and say, okay, now I'm going to differentiate. I'm going to pay you, arguably, a higher base pay, or maybe give you a higher commission, or tweak it a little bit to further incentivize you because you're doing such a great job. I can give you a bonus of more money.
When you're hiring, the pre-hire, what could your discussions be around that?
It would have to be one of those 6 factors. So experience, education, but it has to relate to the job, travel, those types of things. It's really those 6 factors are what's going to do it, or skill, experience, if it relates to the job. Let's say you've got a salesperson selling medical devices, and this person has a engineering degree or had dealt with and understands how they work and can maybe pitch it better. That might be a differentiator. But that's something you really got to analyze.
Mm-hmm.
Yep.
If we use a recruiter and a recruiter violates the act, are we liable or is the recruiter liable?
So when you say a recruiter violates the act, the recruiter is not an employer. So the recruiter can ask the recruitee, the person who you're trying to place the job, right? Place the job for. You can ask them what their salary is, but you cannot and should not share it with the employer. So if an employer who is looking at your candidate says, hey, what's this person's salary? And say, I can't tell you. It's not yours to give up. It's not yours to volunteer. If the employee wants to volunteer it, they can. But I would say from a recruitment standpoint, I would advise you.
Then if we come up with an offer, the recruiter could say, oh, you should probably go higher or something.
I'm sorry?
If we come up with an offer and the recruiter knows what the pay was, because he can ask, he could advise us when we need to go higher.
Well, there I'd get, so I understood you a little bit differently. So if you're saying that the recruiter is working for you, finding somebody for you,
Yes.
I would treat that person as an agent, and I would not have that recruiter ask.
Okay.
If you are more of a placement agency and I'm out there saying,
No.
I have people and, oh, I understand you're looking for somebody, let me give you somebody, that's how I was
This is
answering the
someone
first part.
finding someone for
Yeah.
us. But what if that person asked, but we didn't tell them to ask, That's what I'm...
Well, I think what I would do is when you talk to recruiters, you sit down and say, okay, we all understand here, nobody asks about salary, because they are your agent, they're working for you. If it's the other one where you're placing, I'm trying to place and I'm going to all these employers saying, I've got people who can work for you, that's a little different.
Can you, very quickly, high level, tell me how we should document this process to show evidence that we're, doing what
The process of the self-evaluation, well, you're gonna set up a self-evaluation plan, and you're gonna say, here's what we're gonna do. We're gonna determine what all our positions are. We're gonna gather our job descriptions. We're gonna look to see how they relate to the actual job. We're gonna sit down with our supervisors and say, okay, what do these people do? What are they actually doing? Figure that out. You're going to then say, here's the people who are in comparable jobs. So then I match them up. Here's my sales folks. These are definitely comparable. And then I say, here they are. Here's their genders. Are they paid equally? If not, what are the variations? Are they based, do they fit with any one of those 6 factors? Then you find out, okay, I got some problems. I got some discrepancies. These are the ones. I'm going to fix them, and what's my plan to fix them? And is it reasonable given my size and what the fix is? It's $3,000 difference. I would say you can fix that pretty quick unless, money's really tight, but, depending on the situation. If you've got 500 jobs you got to fix, that may take you a little bit more time. But I mean, happy to talk to you more, but it's a big process. If you look at the guidance, there's attached to the back of the guidance, they give you a broad description of what a self-evaluation plan might look like. Because you can do your own, or you can hire out and have somebody do it too.
Good morning, everybody. I'm going to speak about the Pregnant Workers Fairness Act. Hopefully it does ring a bell because unlike the Equal Pay Act, it is law now. If it doesn't ring a bell, then you should really pay attention. If not, and if this does ring a bell, then this is an opportunity, I guess, to sort of double check your work and double check your policies and make sure that they're in compliance. As I just said, it's law. It became effective April 1st. It was passed by the Massachusetts legislature last summer. Dave Rogers later on might have some comments about that. Interestingly, it was added to the Massachusetts Fair Employment Practices Act, which is 151B. That has two important practical effects. First of all, it means it only applies to employers with more than 6 employees. If you do not employ 6 or more employees, then this act does not apply. The other thing is that it's enforced by the Massachusetts Commission Against Discrimination. In fact, I'll discuss some of the guidance that the Mass Commission Against Discrimination has put out. Now, one area where it's not really a change of the law is that the idea of pregnancy being a protected class, that's not really new. But in terms of what protections expressly go out to pregnant or nursing employees is new. I would say that to boil down the act, you could say that there's three do's and 3 don'ts. The first do for an employer is to provide reasonable accommodations for an employee's pregnancy or condition related to pregnancy. A condition related to pregnancy means something that affects the pregnancy both during and after the pregnancy, not just during the 9 months of pregnancy, but also during the nursing process when there's a newborn infant. The only way to get around a reasonable accommodation is where an employer can prove that the accommodation would create an undue hardship. I'll discuss what an undue hardship is later on. The second do is to engage in a timely, good faith, interactive dialogue with an employee or a prospective employee when that employee or prospective employee makes a request for accommodation. Now, the Act and the guidance don't define what is timely, but obviously with pregnancy there are very time-sensitive accommodations that need to be taken into consideration. So it's important to be very proactive as an employer when an employee or prospective employee comes to you to explain that she is pregnant. The third do is to provide non-bathroom space for employees to express breast milk. That's very important, and that's something that you should be thinking about even if you don't currently have any nursing mothers. It will require some sort of private space that's away from other employees, customers, and the general public. I think that's very important and worth a lot of consideration. In terms of the don'ts, employers cannot take any adverse action against an employee who requests or uses a reasonable accommodation due to pregnancy or related to a condition of pregnancy or refusing to hire a job applicant because of pregnancy. So if you're interviewing someone and they tell you, I'm 3 months pregnant, I'm expecting in 6 months, and that factors into your decision as to whether to not hire that employee, that's a violation of the Act. It also sort of encompasses an anti-retaliation provision. If an employee requests an accommodation, do not retaliate against that employee. Adverse action also includes reinstatement. So if, as part of the accommodation, the employee goes on leave for a certain amount of time, they must be reinstated with equal or equivalent position and equal pay and benefits, including seniority, fringe benefits, retirement accounts. The second don't is do not dictate to your employee what accommodation you believe is appropriate for that employee. The accommodation has to be related to the essential functions. I think one example, just that off the top of my head, if you have a bartender or server who says that they're pregnant and they start to show, and you ask that bartender or server to go to the back of the house, not because of the pregnancy, but because you don't know if people want to be served by someone who's pregnant. That's a violation of the act. The third don't is to require an employee to take leave if the employee wants to stay and work with reasonable accommodation. So obviously, there's the parental leave. There's also FMLA. If you're an employer that is of a size more than 50 employees that the FMLA applies to, or the parental leave, then the option of an unpaid leave of a certain time is an option for the employee, but the employer cannot dictate that to the employee. I don't think that an employee will necessarily be asking for unpaid leave, but if, for example, if you have a paid leave policy, I don't think the employee will mind if you tell the employee that they're welcome to take the paid leave. But if you're going to insist to the employee that they have to take the unpaid leave rather than to accommodate them, then that will create issues under the Act. Unlike the anti-disability discrimination laws, the Pregnant Workers Fairness Act actually spells out several examples of what a reasonable accommodation is. It spells out in the statute 9 different examples of reasonable accommodations for pregnant employees or those who became recent mothers. The first is more frequent or longer paid or unpaid breaks. Whether or not the break is paid or unpaid depends on what the employer's policies are. So in other words, this pregnant or nursing employee can't be treated any worse than other employees. So if the employer permits employees to take 10-minute paid cigarette breaks, then it must provide comparable breaks to a pregnant or nursing employee for other purposes. Another reasonable accommodation is, of course, time off or leave to attend to the pregnancy or to complications relating to pregnancy or to recover from childbirth with or without pay. And again, this is based on what the employer's policy is. So if the employer allows for paid personal time at their discretion and they allow employees to use that paid personal time, then they should also use it for those employees, for the pregnant employees. This also may matter if an employee is not eligible for FMLA leave or parental leave, either because the employer is between 6 and 50 employees, or if the employee has not worked sufficient hours to qualify for a leave. This is basically a way to tie in leave for any employee because of pregnancy, regardless of the size and regardless of the amount of hours that have been worked. 2 other accommodations are job restructuring or a modified work schedule, and then, as I mentioned earlier, the private non-bathroom space for expressing breast milk. 4 other accommodations that are listed under the statute are modified equipment or seating, a temporary transfer to less strenuous or hazardous positions, light duty, which I believe is geared more towards lifting requirements of a job, and then assistance with manual labor. One thing that an employer is not required to do is an employer is not required to discharge or transfer another employee to accommodate the pregnant or nursing employee. So as I said earlier, I would discuss what an undue hardship is, and it's a really hard thing for an employer to meet. The MCAD guidance says expressly that for a hardship to be undue, it must be of a significant expense or difficulty. So that will be very difficult to show. It will be the employer's burden to show the undue hardship. And the statute lists 4 different factors for consideration. It's the 4 are the nature and cost of the needed accommodation, the overall financial resources of the employer, the overall size of the employer's business, and the accommodation's effect on expenses and resources. Basically, the reading between the lines is if you are a big company, you should be able to reasonably accommodate your employees for pregnancy or conditions related to pregnancy. Smaller employers, you may have a better argument, but again, it's a very tough burden to meet, and I would not recommend it is one that you hang your hat on. If you feel like you do need to rely on undue hardship, then you need to think about that very much so when you're engaged in the interactive process with the employee and you're going through back and forth about what the accommodation should be. Now, for those of you who are very familiar with ADA law and accommodating disabled or handicapped employees, you might be saying, okay, I treat pregnancy no different than any disability. That would be a mistake because there's a key distinction between the Pregnant Workers Fairness Act and general anti-discrimination laws for disability and handicap. An employer cannot require medical documentation for 4 different accommodations. Those are more frequent restroom, food and water breaks, seating, limits on lifting more than 20 pounds, or the private non-bathroom space for expressing breast milk. So normally in an ADA accommodation case, you would say to your employee, I'd like to see some medical documentation to corroborate. I'd like to talk to your physician, and we'll fill out the forms. If all they're asking for are one or several of these 4, do not ask for medical documentation. Do not ask to speak with the employee's physician. The other key distinction is that FMLA and parental leave each have set times for the amount of leave. The Pregnant Workers Fairness Act does not set forth that. It will be based on what the circumstances are, whether there's undue hardship to the employer or whether there's some sort of operational difficulty that makes it an unreasonable accommodation. The MCAD has published 2 different guidances. One is just called a guidance, and one is a question and answer format. They're very easy to find on Google or on the MCAD website. I think that might be the first, if you have a question or a concern about your compliance, that might be the first place to go to figure out if you are in compliance. Again, the MCAD defines an undue hardship as significant difficulty or expense, and it also explains that private space for expressing breast milk should be free from intrusion by other employees, visitors, and the public, and should be convenient and comfortable for the employee. Having said that, if an employee has a private office that is sufficiently private, that can also be an appropriate place. It does not need to be away from an employee's desk. It depends on the circumstances. What are some of the important takeaways for how to ensure compliance with the Massachusetts Pregnant Workers Fairness Act? So the first is to ensure that handbooks, written policies, employment notices are up to date. Again, this law already took effect, so to the extent that you don't already have that, you should be doing that promptly. And it should incorporate within it the policies and procedures to ensure compliance with this act. It's important under the act, notice must be given to all new employees and any employee or prospective employee who provides notice to the employer of pregnancy or a condition related to pregnancy. And according to the law, there needs to be notice given within 10 days of the date that an employee provides the notification. So in other words, once the employee provides that notification, whether it's informal or formal, then the clock starts ticking for the employer to provide the written notice. And this could lead to if you have not trained your managerial employees on this, this could lead to very easy technical violations of the act. For example, an employee comes and says, I'm 4 months pregnant, my due date is in 5 months from now, and the managerial employee sits on it for several weeks before notifying HR. The employer has not provided the notice. That's a technical violation of the act, and it's all spelled out there. Ignorance will not be looked at kindly by the MCAD, whoever else is enforcing it. The employer should also always be thinking about reasonable accommodations, what they can offer to their employees, their pregnant employees or their nursing employees, in particular, obviously the private non-bathroom space for expressing breast milk. Make sure that HR staff and managerial employees are trained to not ask for medical documentation depending on what the specific accommodations that the employee asked for. So again, if they're the opportunity to sit during the workday, limits on lifting less than 20 pounds, expressing breast milk in a private non-bathroom space, as well as more frequent restroom breaks, the employer cannot ask for medical documentation. Also, do not think of this as some sort of set time period for leave. It's based on the circumstances, it's based on how that affects the employer's operation and whether the employer can accommodate the employee. Finally, when you have issues, you should consult with either the MCAD guidance or the Q&A, or you should contact an attorney, whether it's in-house or someone at our firm would be happy to speak with you about that.
The MeToo movement. Even as dramatic headlines have captured attention, many women report that they've seen zero changes in their workplaces. So what can you do as an employer to protect your employees, to improve the quality of your workplace experience, and to protect your company and your supervisors and managers from liability? Well, this is stuff I've been telling employers for a long time, and it's very important in this day and age, in this time, that we focus on this and that we do our very best to comply with the requirements and go beyond. Zero tolerance is really the catchphrase that we all need to have in mind. Make sure you have an updated sexual harassment policy and complaint procedure in place. Make sure it's current. Make sure you have at least one male and one female designated and trained to receive complaints of sexual harassment. Require supervisors and managers to attend workplace training on this topic. Make sure they can spot the issues. Make sure that they're not putting their heads in the sand when they see a potential issue, but rather that they're going out, talking to their folks, and pursuing potential problems that they perceive. Make sure they know how to handle it when somebody comes to them with a complaint. Require employees to attend training. Make sure your employees know what they are entitled to in your workplace, that you have a zero tolerance policy, and that they can go to a manager or supervisor or one of the designated individuals to bring a complaint or concern. What is unlawful harassment? This is a primer in basic harassment law. Unlawful harassment occurs when a worker is subjected to a hostile work environment because of their protected status. That's the general broad definition of unlawful harassment under the anti-discrimination laws. And what are the protected characteristics, the protected categories? Here's a list: age, race, color, sex, which includes pregnancy and caregiver status, national origin, sexual orientation, gender identity, military service, veteran status, disability, genetic information. Harassment, discrimination based on any of these characteristics is unlawful under state and federal law. What constitutes harassment? It can be verbal, it can be visual, an image, a cartoon, it can be physical. Once I was at a workplace of a client investigating a sexual harassment complaint, and I went in their lunchroom to get some water or something, and I see on their refrigerator, on their magnets, are all these really racy comic strips, dirty comics on their refrigerator. And so there I am, I'm their lawyer, they're paying me a lot of money, and I'm pulling the stuff off of their refrigerator. I then went and talked to the person who is the head of leadership in this company, and I'm talking to him, and as we're talking, I see that his screensaver is, you guessed it, a sexually inappropriate image that's flashing across his screen every few seconds as we're having this conversation. Yeah. Think. Be careful. Keep your eyes out. Train your managers so that they understand what to be looking for and they understand how important this is. So, harassment generally can be slurs or negative stereotypes. I cannot read this small. It can be insulting jokes about particular racial groups or protected categories of people, insulting or offensive emails, insulting or offensive posters, screensavers, as I just mentioned, derogatory comments or taunts about someone's race or religion or other characteristics, intrusive questions about someone's personal life, for example, obviously touching that is uncomfortable, intimidating, or offensive, gesturing that is offensive, intimidating, or insulting, Now, sexual harassment is a particular kind of unlawful harassment. There are two kinds of sexual harassment. One is quid pro quo, which in Latin is this for that. And the other is the one that we see more frequently and that you're more familiar with most likely, which is a hostile work environment sexual harassment. Now just quickly, quid pro quo sexual harassment, unwelcome sexual advances or requests for sexual favors when submission to the conduct is made either an explicit or implicit condition of employment, or submission to or rejection of the conduct is used as a basis for an employment decision affecting the harassed employee. Go on a date with me or you're not going to get this promotion. You know, let me put my hand on your knee and you can be my assistant and I'll give you a big raise. Hostile work environment. Again, we see this a lot more commonly. This is verbal, visual, or physical conduct of a sexual nature when the conduct interferes with any employee's work performance or creates an intimidating, insulting, or offensive environment in the workplace for that employee. So what are the questions that we ask to consider whether hostile work environment sexual harassment exists? We ask, is the conduct sexual in nature? Is the conduct unwelcome? Is the conduct severe or pervasive? Let's talk about welcome versus unwelcome. What does that mean? Well, the person complaining must find the behavior unwelcome, right? It's not about whether somebody else thinks the conduct would be unwelcome to them. It's about whether that person considers it unwelcome in the sense that he or she did not invite it, did not solicit it, did not participate equally in the behavior. Welcome versus unwelcome. It's a matter of perspective. You all have seen this image before. I'm sure if you look at it one way, it's two faces facing each other. If you look at another way, it's a vase or a goblet. The question of whether certain conduct is welcome or unwelcome is based on the perspective of the complaining party. Be aware. Again, zero tolerance is our catchphrase. Employee misconduct need not rise to the level of unlawful harassment before disciplinary action is appropriate. Be on the lookout. If you or your managers or supervisors perceive anything that appears to be inappropriate, that is something that might be sexual in nature or perceived as sexual in nature, address it. Managers should be alert to conduct that exceeds the bounds of civil, respectful workplace behavior. Now, I do a lot of workplace trainings, and oftentimes I get a lot of discussion going, and it can be a lot of fun. One of the things I hear a lot from employees is, you know, there's no fun in the workplace anymore, right? You can't say the slightest thing. You can't look at somebody the wrong way. You can't just, give somebody a friendly tap on the shoulder without being afraid that they're going to allege that you're a sexual harasser. And I understand that this is difficult. But what I say to people is, this is the workplace norm. The workplace norm today is different from how it was years ago. My dad called me a few years ago and said that he was very proud of himself because he had given his secretary a Victoria's Secret gift card for her birthday. And he had written in the card, I look forward to going with you when you try on stuff at Victoria's Secret. My dad passed away recently. He was already in his late 70s when he told me this story. You can imagine how I reacted, his employment lawyer daughter. But my point being that times have changed, and what was appropriate on Mad Men doesn't fly. And so we all have to be very careful. And as I say to the folks in the workplace trainings when they have these complaints, what's okay for you to say to your buddies when your feet are on the coffee table watching a football game is totally different from what's okay to say to your workplace buddies in the workplace. So be careful. Train your managers. Have workplace trainings. Make sure that everyone is on the alert and that issues are addressed, nipped in the bud, before somebody complains about being uncomfortable. Counseling is appropriate. When I say counseling, I mean preliminary discipline, having a conversation with an employee, even if the inappropriate conduct is perceived to be minor or an isolated one-time incident. Isn't it better to address that early on, again, nip it in the bud, rather than have something fester or develop into an uncomfortable situation that's going to cause problems, lost productivity, potential loss of an employee, and potential liability, and it's going to cost you a lot of time and effort to deal with it. All inappropriate conduct that might be construed as harassing or sexual in nature should be discussed and addressed. Open conversation and communication is the key. Some common misconceptions. I only meant to be funny. I wasn't harassing anyone. We see this all the time in our sexual harassment cases. Conduct that has the effect, again, it's in the eye of the beholder, the effect of creating a hostile work environment is prohibited. And what is hilarious to one person can be offensive to another. We all know that. Romantic relationships between two employees are harmless. It happens all the time. It does happen all the time. But employers have to think about whether they want to have a policy relating to relationships. For example, relationships between a supervisor and a subordinate. Should that be a situation where they have to report, they have to disclose, because you don't want romantic relationships in that power dynamic? And maybe somebody needs to be transferred, or maybe this needs to be addressed in some way. Think about what your policy should be, because others may be offended or perceive favoritism. And if the couple breaks up, we often see alleged sexual harassment arise. Other common misconceptions. It's not sexual harassment. It is if the conduct is between two people of the same gender. That's absolutely not true. Same-sex harassment is unlawful, according to the Supreme Court. Another misconception, very important. Most of you in your businesses have vendors. Even the mail carrier coming on your premises, you're responsible for third-party conduct in your workplace. Nothing can be done if the harassment is by a client, customer, vendor, or other employee. Wrong. Harassment by non-employees is likewise prohibited with respect to your workforce, your employees. They're your responsibility. Your managers and supervisors need to know how to handle complaints. And when I say a complaint, I don't necessarily mean somebody saying, I want to lodge a formal complaint, or giving you something in writing. I'm talking about even an offhand remark regarding some kind of concern. How do your managers and supervisors deal with that? They need to be trained to deal with that. The basics are, of course, you want your managers and supervisors to be respectful and listen. If someone comes to you, if you perceive a problem, be respectful, listen, take notes. Very important. And this is where this gets tricky and why training is important. On the one hand, you all have good people skills. You're listening, you're nodding, you're being empathetic. But at the same time, you don't want to do anything that's going to throw your company or your supervisor or manager under the bus, right? So you have to be careful not to in any way make an inadvertent admission. You don't want to characterize the behavior as inappropriate. You don't want to characterize the behavior as constituting harassment in this conversation. You can repeat back to the employee what happened. You can certainly elicit more information. You can let them know that you are listening and that you care about them. But be very careful not to say, gee, that sure is inappropriate, or yeah, I can understand how you feel harassed. We want to be careful as employers to protect ourselves against liability. And so it's tough. It's tough. It's not easy. Tell the employee that you must discuss the situation with HR or legal counsel. Your managers and supervisors need to understand this. Once a manager or supervisor is on notice of the potential existence of sexual harassment, they have an affirmative duty to report that up. They have an affirmative duty to make sure that that situation is addressed properly. Now, interestingly, this comes up all the time. You want to assure your employees that confidentiality will be respected to the fullest extent possible. Now, in the MeToo movement, we're seeing the press. One of the things that often is objected to now is that in settlements, there often is a non-disclosure or confidentiality provision. And people feel that these are gag orders and that people shouldn't be paid in exchange for silence. And I understand that. But the reality, in my experience, is that when people come to you with complaints of sexual harassment, usually they are looking for confidentiality. They're asking you for confidentiality because they're concerned about retaliation, they're concerned about their reputation. They don't necessarily want to get somebody else in trouble. they just want the situation addressed and they want to be comfortable in their work environment. So what you have to tell them is, we will respect your confidentiality to the fullest extent possible, because you can't completely keep it under wraps, right? You've got that affirmative duty to report it up and investigate it, address it, remedy it. So you can assure the employee who's concerned about their confidentiality, who's concerned about their privacy, that you'll respect that to the fullest extent possible. The next step is an investigation. Obviously, you want to work with your HR folks, with your legal counsel, to make sure that there is a prompt and impartial investigation of the situation. There needs to be a fair amount of effort put into who will do the investigating. It needs to be a neutral fact finder, and who will be spoken with as part of the investigation. And then it is your responsibility as an employer, based on the results of that investigation, to address and to remedy the situation, which can involve corrective action. It can be something creative. You might be just moving people's desks. You might be terminating somebody, depending on the severity of the circumstances. As I said at the beginning, you have to have your harassment policy in place. It has to be updated. Make sure that it includes an explanation of exactly what constitutes prohibited conduct. Make sure it talks about your zero tolerance policy. Make sure a complaint procedure is in place that provides alternative avenues for reporting. Remember, at the beginning I said at least one man and one woman should be designated and trained. You have to assure people in your policy that they will be protected against retaliation if they bring a complaint or support a complaint or provide information that supports a complaint. There was a case not long ago in Massachusetts where someone was interviewed as part of an investigation, and she spoke up and said the truth, which was that she had observed some inappropriate conduct by the person who was being accused of the harassment. She was promptly terminated. Retaliation. Obviously, you're not going to do that, but retaliation can be subtle, so we want to be careful to protect people who have made a complaint or participated in the investigation or supported a complainant. Again, prompt, thorough, impartial investigation is required. This is something that people need to be trained on. You should be talking to your legal counsel about. And then corrective action when warranted. Again, that can run the gamut depending on the seriousness of the situation and the circumstances, the people involved. And of course, counseling or training when warranted. Oftentimes, counseling, discipline, training, making sure people understand what the expectations are, can be very helpful and can help you achieve that zero tolerance workplace.
So I think my friends, my family, my colleagues would be shocked to hear me talking about anything political, anything having to do with this presidency. So this would probably be a first-time event for everyone in my circle of the world. But there is the old truism that elections have consequences. And in this small sliver of the national agenda, being employment law, labor law, as I'm going to go through in the next 10 minutes or so, elections have, this election, as any election, has real significant consequences and has had for employers and employees. So I'm going to first talk about the National Labor Relations Board, and just 10-second background. We have in this country the National Labor Relations Act, the NLRA, which is an act to protect workers, employees' rights to organize, to unionize, to discuss, engage in concerted activity for their health and welfare benefit. The National Labor Relations Board is an independent federal agency which has judiciary-type authority to enforce the NLRA, the National Labor Relations Act. The National Labor Relations Act applies to every employer in the country, whether you're unionized already or not. That's a common misconception that it only applies to unionized employers. So the reality is that the NLRB has something to say about every workplace in the country, whether unionized or not. So following the election, in 2017, President Trump appointed two Republicans to the NLRB. The NLRB is a 5-person board, subject to appointment by the president, subject to confirmation by the Senate. So with President Trump's 2 appointees, the board is now made up of 3 Republicans and 2 Democrats. The new chair of the board has 30 years experience representing companies in private practice. If you're an employer management side person, you may be happy with some of the actions that have quickly been taken at the NLRB under the new administration. If you're a union person, a union organizer, an employee rights person, you'll be less happy than that, than the employer side. I will say here at Davis Malm, we do both sides of the aisle. So we represent employers, we represent management, we represent employees. So we have no political hunt in this game. The new general counsel of the NLRB, when he came in, quickly issued a memo signaling his intention, identifying several Obama-era decisions that the new board and that he in his role as general counsel was going to seek to readdress, including handbook rules, employee rights to use company email systems, and the doctrine of joint employment. For those of you who have attended our annual employment law update in years past, we have spent, I think, a couple of times at least, we've talked about employer policies, social media policies, handbook policies, and the impact that the NLRB rulings have had on employment policies. And it's been hard to make sense of it over the years, but there's been a lot of policies that have been struck down by the NLRB, basic employment handbook policies that the NLRB has found not to pass muster under the NLRA. And we're going to talk about where those decisions stand now, because there's been a significant reversal. So the general counsel issued a memo, and there have been already several Obama-era precedents that have already been overturned, and you can be sure that more will come. So Section 7, just a little primer, of the National Labor Relations Act protects employees' concerted activity, which means when employees take action or engage in communications for their mutual aid or protection regarding the terms and conditions of employment. So it includes such things as picketing, as union organizing campaigns, or even more than one employees getting together talking about compensation, their salary, the employer's pay practices, workplace rules, and employment policies. It's a wide range, but any of that, any such discussions, any concerted activity along those lines could be seen as being protected by Section 7 of the NLRA, again, whether or not you're a union employer. So it applies to non-union employees. So a policy, an employment policy, an employer policy will be unlawful under the NLRA if it explicitly restricts Section 7 activity, was adopted in response to protected activity, or was applied to restrict section activity. So over the last 8 years plus, the NLRB had been striking down any employer policy, and we'll talk about policies like general employment law handbooks. If you're an employer, you probably have or should have an employee handbook, and the NLRB had been striking down employer policies under Section 7 on the test that whether it could find that the policy could be, quote, reasonably construed by an employee as impinging on Section 7 rights. So it was a one-sided analysis by the NLRB under the Obama era. If a policy could be reasonably construed by an employee as impacting his or her Section 7 rights, the NLRB was striking down these policies, and that's what's called in legal jargon in our world the Lutheran Heritage Standard. That's the case in which that policy, that standard was developed, the reasonably construed standard. The board was not giving due consideration to an employer's legitimate justification for the policy. And over the years, this led to, just to put it simply, nonsensical and irreconcilable results. For instance, policies that the NLRB struck down under the reasonably construed standard, including Policies that advised employees to, quote, work harmoniously was struck down. And policies that encouraged employees to conduct themselves in a, quote, positive and professional manner was struck down. Policy that prohibited loud, abusive, or foul language was struck down. Policies upheld under this standard, quote, no abusive or threatening language to anyone on company premises was upheld. I would challenge anyone to make a principled distinction between policies that have been struck down versus policies that have been upheld. Prohibiting conduct that not support the employer's goals and objectives was upheld. So it was difficult to evaluate for us as lawyers, for you as clients. What do people like? People like, I think, whichever way it comes out, people like consistency and predictability. We do a lot of handbook, we write a lot of employee policies, employee handbooks here, social media policies, confidentiality policies, the entire range of employee policies. Over the years, clients would come to us and say, well, is this policy, is this handbook going to withstand scrutiny? And it's been very, very difficult, as you can see here, to answer with any degree of confidence and predictability as to what the NLRB, if challenged, would uphold and what it would strike down. So now in December of 2017, the NLRB issued the Boeing decision. That's what it's called. And that was the case. It was a case brought against the Boeing company. And the NLRB concluded in that Boeing decision that the, quote, reasonably construed standard is incorrect as a matter of law. So let me just talk a minute about what the Boeing decision was to put it in context. Boeing had issued a no camera rule within the workplace. And what that really meant was no camera rule, no camera use without express permission, with warning. So Boeing, as we all know, Boeing is an aircraft manufacturer. We all know that. Boeing is also a defense contractor, a substantial defense contractor. Boeing deals with highly confidential, top secret, sensitive information in its defense work and in its aerospace work. Boeing facilities are targets of espionage. Boeing's facilities are targets of terrorist attacks or terrorist activity. Because of those interests, Boeing adopted a no-camera rule restricting the use of camera-enabled devices. And in this day and age, that includes every single person's mobile phone. Your iPad, your phones, PDAs, everything, every device that every person carries was subject to this policy while on Boeing's property. Now, the administrative law judge, an employee challenged the policy, claiming that it interfered with his rights to engage in concerted activity and take pictures on premises and establish workplace conditions. And the administrative law judge struck down the no-camera rule on the grounds that employees would reasonably construe, using the reasonably construe test, that the rule to interfere with protected Section 7 activity. The administrative law judge gave no weight to Boeing's security needs. On appeal, the full board struck down the Lutheran Heritage Standard. The board adopted a new analysis for evaluating a facially neutral policy. So here again, I want to emphasize what we're talking about only are policies that on their face are neutral. If a policy said employees cannot picket the premises, employees cannot engage in discussion about their salary, their compensation, the terms and conditions of employment, those on their face would violate Section 7. They would not withstand scrutiny. So what we're talking about are policies that on their face are neutral, but under the old Lutheran Heritage Standard, if an employee would reasonably construe it as impinging on their rights without any consideration to the employer's justification, that policy could have been struck down. So the new analysis that's now adopted is now called the Boeing Standard, is that any facially neutral policy will be evaluated for its nature, the nature and extent of its potential impact on Section 7 rights and the employer's legitimate justifications for the policy. So, and then the board emphasized its duty under the NLRA itself and under Supreme Court precedent that there is a duty to properly balance between legitimate business justifications and the invasion of employee rights. That balance had gone out of whack in the Lutheran Heritage Standard. It's now been reinforced, and the full board overturned the administrative law judge's determination striking down Boeing's no camera policy. This does not mean that all employer policies will be upheld. For instance, in a decision from last month, a NLRB administrative law judge was faced looking at a confidential information policy that prohibited employees from talking about salary information. That policy had been struck down under Boeing, but the judge found this to be a per se unlawful policy and engaged in, so it found the policy on its face, the judge, to be a per se unlawful policy. So the judge didn't have to take it any further, but in light of Boeing and the newness of the Boeing standard, the judge took it further and said, well, I will now evaluate this under the new Boeing standard, and found that under the Boeing balancing test, in this case, this was a case against Lowe's hardware store, the judge found that Lowe's justifications did not outweigh the employee's rights to discuss their wages. So it's just a reminder that now that even though we have the new Boeing standard, which will require a consideration of the employer's justification, legitimate justification, that does not mean that every policy will be upheld under Boeing. And this was a good example of a facially invalid policy, which did not even meet, if you went beyond that, the Boeing standard. So, so moving forward, it provides us as lawyers writing policies, a little bit more predictability and guidance in how to in addressing your policies, and so you should all keep that in mind. The other big issue that's been impacted in the Trump era with the new board is the law of joint employment, joint employer status. Just a week or two ago, actually, on May 9th, the NLRB chairman referred to the joint employer standard as, quote, one of the most critical issues in labor law today. The joint employer standard determines the scope of employer liability in a number of settings, franchisor, franchisee relationships, independent contractor relationships, contingent worker relationships. All of those relationships and then some can be implicated by the joint employer doctrine, which that means that there could be an expansive scope of liability for unlawful activity. Substantial financial consequences for failure to pay compensation, misclassification of exempt status or independent contractor status, unfair labor practices, and breaches of collective bargaining agreements. So in a franchisor-franchisee relationship, for instance, you take a franchisor like McDonald's, it's got an independent franchisee who, at that particular location, the franchisee is setting their own terms and conditions of compensation, wages, employee relations. Under an expansive view of the joint employer doctrine, the franchisor could be liable for unlawful conduct, unlawful pay practices, unlawful NLRA activity at the local franchisee level. Over the last several years, this doctrine has had a tortured history. In 2015, the board issued the Browning-Ferris decision, and this was a broad expansion of joint employer liability. Browning-Ferris made new law in broadening the scope of joint employer liability. It got a lot of attention in the employment world, employment law world, in the franchisor world. And what the Browning-Ferris decision did, it found that the mere right to exercise minimal or indirect control over terms and conditions of employment, even if not actually exercised. So the mere right to exercise even minimal control created a joint employer relationship, and that with all the attendant liabilities that went along with that. So it was it's been a controversial decision, Browning-Ferris, but in 2015 that became the law. In December of 2017, under the new administration, under the new NLRB, the board issued what's called the Highbrand decision, explicitly and expressly overruling Browning-Ferris, reinstating the pre-Browning-Ferris, pre-2015 more employer-friendly standard. Under Highbrand, the Highbrand decision, it required actual exercise of meaningful control, not potential exercise of minimal control. So now the standard became actual exercise of meaningful control over essential employment terms for there to be a finding of joint employer liability. Employer must act directly and immediately, or one company must act directly and immediately in a manner that is not limited and routine. So a substantial reversal, in the business community widely hailed the Highbrand decision. However, so the result on the Highbrand is that joint employer will not be found liable, joint employer liability will not be found where one entity has exercised only indirect control, has contractually reserved control that never exercised, or control that's only limited and routine. Sounds good for employers, sounds good for management practices. However, Highbrand is no longer good law. On February 26th of this year, the NLRB vacated the Highbrand decision. The NLRB Ethics Office, the Inspector General, found that the President Trump's appointee, William Emanuel, should not have participated in the Highbrand decision. Why? Because he was a partner at the Littler firm who represented the parties in the Browning-Ferris decision. And Browning-Ferris was still going on while this commissioner cast one of the deciding votes in favor of overruling it. And that was found to have violated his ethical obligations. And so the board vacated the Highbrand decision. And as of today, Browning-Ferris is back to being the current law on joint employment relationships. And so contractor, subcontractors, franchisor, franchisee, user, suppliers, parent, subsidiary, everyone now faces the broad joint definition of employer, broad definition of joint employer. However, on May 9th, the NLRB changed its approach and announced that the board is now going to consider a rulemaking process to determine joint employer status. So the NLRB just a couple weeks ago announced that a rulemaking process is underway. That's highly unusual for the NLRB. It's a rare means to establish standards under labor law. And if the board decides to publish a proposed rule, the public will have an opportunity to submit comments for consideration. So everyone will have an opportunity. We're not at that stage yet. They're having just announced that they're going to undergo this process. So to be decided, pay attention. We'll keep you advised. But right now, going forward, we're back to the Browning-Ferris. Lastly, I've got to wrap it up. There was a lot of attention in 2016 given to the new regulations on overtime rules. So the exempt status and overtime rules, you may recall that under the Obama administration, a new rule was issued that raised the minimum salary required to have someone be treated as an exempt employee from $23,660 annually to $47,476 annually. That was a big change, got a lot of attention. Employers, lawyers trying to figure out what to do about that. The net result of that rule, the final rule, would result in a large number of previously exempt employees now being reclassified as non-exempt, meaning that they would be entitled to overtime. So you had a whole class, thousands and thousands of low managerial level employees who were paid a salary, treated as exempt from overtime, who under the new rule would now be classified as non-exempt, be subject to getting paid overtime. Management didn't like it, employers didn't like it. Frankly, a lot of employees didn't like it because employees like being treated, for their own self-esteem, like to be seen as managerial employees, not keeping track of their hours, not getting overtime. But it has real consequences for what's a living wage and people being able to support themselves with one job. The rule came into effect, and immediately multiple actions were filed, 2 in the Eastern District of Texas, challenging the enforcement, challenging the legality of the final rule. And on December 1, 2016, a district court in Texas issued a preliminary injunction preventing the final rule from going into effect. In August of last year, that court issued a final judgment that the Department of Labor exceeded its authority and declared the final rule to be unlawful. That's where we stand right now. So all that publicity about raising the minimum salary and the salary basis test, that's off to the side. That's been enjoined from coming into effect. The current administration at the Department of Labor has indicated that it's going to revisit the rule. We don't have yet a proposed rule. Commentators who follow the Department of Labor closely expect that a new rule will come out and expect that the minimum salary basis will be increased, but not to the level that it was under the Obama final rule.
Due to increased accessibility to marijuana, there's bad news and there's good news. The bad news is that more kids are flunking out of school, but the good news is that their parents couldn't care less. So I'm going to talk about both medicinal marijuana, medical use of marijuana, and adult use of marijuana, and how it affects you as employers and what you need to know. Last July, a decision came down from the Supreme Judicial Court of Massachusetts in a case called Barbuto. And Miss Barbuto had Crohn's disease. She used a small amount of prescribed marijuana in the evenings to stimulate her appetite. She started a new job, and after one day at the new job, she was terminated because she had failed the company's drug test. Even though during her recruitment process, she had told them she was going to fail the test because of her medicinal, legitimate, prescribed use of marijuana. After one day, they got the results back and they terminated her. They told her that they were terminating her because marijuana use is illegal under federal law, and so they had a right to do this. Due to her Crohn's disease, Ms. Barbuto was, according to the Supreme Judicial Court, a qualified handicapped worker. And you know what that means. It means she was entitled to reasonable accommodation for this disability under mass anti-discrimination law and consistent with the new Massachusetts marijuana legislation for medicinal use. Allowing an employee with a disability to test positive due to off-site use of marijuana for legitimate prescribed medical purposes is a type of accommodation that is required as long as it is reasonable. And Robert talked to you a little bit about what constitutes reasonable accommodation. An accommodation is reasonable if there's no undue hardship on the employer for allowing that accommodation. An undue hardship would exist in this situation, according to the Supreme Judicial Court, if allowing the positive drug test, presumably in violation of your normal rules, would cause the employer to violate a contract or statute. So say, for example, you're a federal contractor. A federal contractor would not have been required to accommodate Ms. Barbuto because doing so would violate their contract with the federal government, therefore creating an undue hardship for that particular employer. Federal contractors are not required to allow even off-site medicinal, legitimate, prescribed marijuana use by their employees for this reason. Another example of an undue hardship would be a company, such as maybe one of yours, that employs professional drivers, and therefore you're regulated by the Massachusetts Department of Transportation. So, for example, allowing a bus driver to test positive in violation of your standard drug testing rule, even for off-site legitimate prescribed medical marijuana, would be an undue hardship for a bus company because it's not a reasonable accommodation under the Department of Transportation rules, which prohibit positive testing for marijuana for drivers. And I know that that is a policy that's enforced aggressively by the state government, so in that case, you would not have an obligation to provide this accommodation. It would not be reasonable for you. Exempting an employee from a workplace drug testing policy for off-site medicinal use of marijuana may also be an undue hardship and therefore, again, not a reasonable accommodation and not required when the position involved is what we call a safety-sensitive position. This might be, for example, jobs that require operation of heavy machinery, operation of a motor vehicle, certain warehouse jobs where you are using forklifts, where you're lifting and moving heavy pallets or boxes. In these situations, it may be an undue hardship for you because it's a safety-sensitive job to allow somebody who tests positive in violation of your drug testing policy. To be clear, this law, the Supreme Judicial Court case, applies to only off-site use, right? It doesn't apply to on-site use. As an employer, you still have every absolute right to establish a policy and strictly enforce a drug-free workplace in all instances. So again, it's just off-site use for medicinal purposes that requires accommodation within reason, reasonable accommodation in the absence of undue hardship. Now, let me move on to recreational or adult use marijuana. I can tell you from my experience that employers are confused and uncertain about recreational marijuana use, and for good reason, because it's legal under state law, it's illegal under federal law. And where the use is not for medical reasons to address a disability, as we just discussed, employers do not have an obligation to provide reasonable accommodation. So the marijuana law provides very little guidance to employers. I can tell you one thing that is clear. Again, as with medical marijuana use, employers absolutely may prohibit on-site use of marijuana and use of marijuana while on the job. You can also prohibit working while under the influence. Drug-free workplace policies are appropriate and they're enforceable. The problem is the drug testing. The problem arises with application of employers' drug testing policies. Marijuana is known to stay in the bloodstream for days or weeks, and there's no reliable test to determine, like a breathalyzer, if somebody is currently under the influence. So let me give you 5 points of clear guidance. Number one, be clear that your employees are never allowed to use marijuana while in the workplace or on the job. Number two, be clear that employees are never allowed to come to work or perform any job duties under the influence. Number three, this is important, spend time thinking through your drug testing policies, both your pre-hire screening and your random drug testing policies. Does it make sense to preclude from your workforce anyone who tests positive for marijuana? Considering how commonplace marijuana use is, perhaps limiting employment to only those who test negative for marijuana is not a good business decision for your business. Only you can decide. Think about special circumstances in which it is absolutely appropriate and in fact necessary to drug test for marijuana use and strictly enforce a no drugs policy, a drug testing policy. For example, as we discussed, you should not be employing anyone who tests positive if doing so will violate a federal contract, if doing so will violate a statute, or if a person is in a safety sensitive position, again, operating heavy equipment, operating a motor vehicle. I always remind clients, and this is number 5, that they have an absolute right to discipline and terminate employees for performance-based reasons. And I always want to remind my clients of this, because if you decide to forego drug testing for marijuana among your employees in non-safety sensitive positions, and you find that somebody is slacking off, is behaving inappropriately, is demonstrating that they can't do their job, regardless of whether it's because of their use of marijuana, legal or illegal, you've got a performance problem. And it's appropriate, therefore, to discipline, to counsel, to work with that employee, if necessary, to terminate that employee, again, based on performance reasons. That's my advice to you. Enjoy your marijuana.
So, good morning, everybody. I'm Dave Rogers. I'm of counsel here. I mostly do business law. I do some employment work in the context of business law, employment agreements and the like. And apparently I cannot resist a little shameless self-promotion. As Tamsin said, that is Governor Baker handing me the pen that he just used to sign the Pregnant Workers Fairness Act, which is a bill I introduced, and as Rob so ably described. And it had really bipartisan support. In the House, where I serve, every single member, Democrat and Republican, voted for it. And we had a lot of support from the business community, actually, and they helped negotiate a good conclusion there. So I'm going to go through fairly quickly what's happening in state law right now that could affect the employment arena. And the action really is in ballot questions. Maybe you've been following this, maybe not. Like most states, we have a ballot referendum process where citizens groups can put a law on the ballot for voters to decide. That's how marijuana, at least adult use marijuana, became legal here. The voters approved it. Right now, there are 3 big ballot questions brewing. One is paid family and medical leave. I'm told it's polling well. That's how earned sick time became law here, ballot question. And the same group, Raise Up Massachusetts, it's an umbrella group of about 150 organizations, unions, is pushing that. Raising the minimum wage to $15 an hour is another ballot question. And even if you don't have a lot of minimum wage workers, that's going to tend to put upward pressure on all wages if it passes. And finally, a reduction in the state sales tax, which might not immediately be obvious, but the reason that is important is the way the ballot question process works is first, the Attorney General has to certify it's appropriate to be on the ballot. Not everything can go on the ballot. Then the group has to gather a lot of signatures, but then it comes back to us in the legislature to see if we can get a deal done so it doesn't have to go to the ballot. Ballot fights are very expensive, time consuming, and that's where it is now. It's in the State House. And so the retailers who have a reduction in the state sales tax are saying, maybe we'll back off our ballot question to reduce the sales tax if you give us some relief on the minimum wage and the Paid Family and Medical Leave Act. And I just met with the chair of Labor and Workforce Development yesterday. Those negotiations are ongoing. And I said, what do you think? He said, it's a coin toss. He said, I don't know if we're going to reach a deal or not. So these could be going to the ballot. So I'm going to try to tick through them. And you can always follow up with me on anything. I'm happy to give clients advice as to generally what's happening at the State House. So paid family and medical leave would give 16 weeks of paid family and medical leave. And that is, unlike Family Medical Leave Act now, or the Small Necessities Leave Act, which is in Massachusetts, or the Pregnant Workers Fairness Act, this leave is paid. It's paid family medical leave. It's to care for a seriously ill or injured family member, care for a new child, or to meet family needs arising from military service. That's the family leave part. The medical leave part is to recover from an employee's own illness or injury. That's up to 26 weeks, half a year of paid leave, or to care for a seriously injured family member. It will be funded by contributions to a family and medical leave trust fund, which is 0.6 of 1 penny of weekly wages would automatically go into that trust fund. The employer can require that the employee fund 50% of it, fund half of it from a payroll deduction. It would be a maximum of $1,000 a week, and like other laws protecting employees, there can be no retaliation for asserting the right. And if you talk to plaintiffs' lawyers, they'll often say, I couldn't prove my case for a violation of national origin or discrimination on gender or discrimination on any other, but they retaliated. So retaliation is important. Now, the next piece is the minimum wage, and that would raise the minimum wage $1 an hour for the next 4 years. So we're at 11 now. It would go to 12, 13, 14, and 15 over the next 4 years. And that would also raise, for those in the restaurant business, the tipped wage for servers. Again, it's not clear what's going to happen, but just like for those of you who were last year, I predicted Pregnant Workers Fairness Act would become law. You can never say for sure, but I think these two are likely to become law. We're likely to have paid family and medical leave in our state. We're likely to see an increase to the minimum wage. It'll be up to the voters probably. I'll just do 2 more things. There's always 30 or 40 or 50 laws that could affect employers in the workplace, but I've just picked 2. One is non-compete law. Non-compete law in our state, as many of you may know, is decided by judge-made law, case law. There's a movement to codify that in statute. And right now, it was reported out of the Labor and Workforce Development Committee, so it goes to Ways and Means, where it will get further consideration. It would limit employers to 12 months in most circumstances for the duration. It has to be reasonable in geographic scope. It does have a garden leave provision, which says the employee must be paid up to 50% of their salary while they're in this non-compete period. And it bars non-competes for certain types of low-level workers. And then the final thing I'll talk about is the wage theft law. And for any of you who may be in the construction business, although this could apply beyond the construction industry, the big piece there is that it says a general contractor can be liable for the violations of a subcontractor. As you can imagine, that's being hard fought. It's controversial. What the advocates say is, look, most generals know their subs who have a spotty track record on wage payment. And as you can imagine, general contractors are pushing back pretty hard. But the wage law is very powerful in our state. It can provide for up to treble damages. The senior officers of a company can be named directly in these lawsuits, so it's an amendment to our payment of wages law. And that's another one that also got reported out favorably and is in the mix. It's tough to say what's going to happen, but I'm always, again, happy to answer questions. And so there's a lot going on, particularly with the ballot questions. And thanks a lot.
All right, that concludes the presentation. Thank you, everyone, for coming. We'll be here if anyone has questions or want to chat about any of the topics or anything else relating to employment law. We'll be around, so feel free to stick around and eat some more food and drink some coffee, and we'll be here. But thanks again for coming. We look forward to doing this again next year. Thank you, everyone.